This is case number 25-5055SM. Francis Counsel, starting with the prosecutor.
Ray Lawrence on behalf of the people.
Allison Castles on behalf of Mr. Burris.
Ms. Castle joins us by Zoom. Mr. Burris is in the courtroom. We are here for a sentencing to a plea taken back on January 7th, 2026 for domestic violence with 4A. The court had requested a pre-sentence investigation report be done. I have received a copy of that. Ms. Castles, have you received a copy as well?
Yes, Your Honor.
Ms. Lawrence?
Yes, Your Honor.
Do either of you have any additions or corrections to it?
No, Your Honor.
All right. Ms. Lawrence, do we have any victim input?
She would like to make a statement.
Ma'am, can I get you to state your name for the record, please?
Malia Harris.
All right. And Ms. Harris, what is it that you'd like me to consider?
For one, I want to say good afternoon, Your Honor. I'd like to start by apologizing to the court system and the people of Wexford County. I came from a broken home and wouldn't wish a broken home on anyone. When meeting Skylar, he presented himself in a different manner. After knowing from him for 6 months, things quickly changed when he found out I was pregnant. Skylar found out I was pregnant December 4th. His demeanor towards me quickly changed to insults and threats. The day of the incident, December 8th, 2025, I was looking to have a civil conversation with who I was supposed to be my significant other. When simply tapping his phone looking for a response back, he responded back in malicious. When throwing my phone in the moving vehicle, there was already intent to harm. The act of breaking a moving vehicle's windshield puts my life, my unborn child's life, Skylar's life, and anyone on the roadway at risk. In this scenario, I'm lucky my phone hit the dash, but in reality, my phone could have flew anywhere in the moving vehicle with extreme force behind it. After breaking my windshield, I didn't black out. I was more in shock behind a malicious action. I calmly asked Skylar why and he acknowledged back that's what I deserve in a taunting way. I do admit to open palming Skylar once, and that is my wrong action committed, but there was no need for self-defense as I was the driver, sir. In no way, Your Honor, did I black out or intend harm on Skylar. I received 3 to 4 serious blows to the back of my head while driving. And there was no remorse for me or my unborn child's life after going into the ditch driving 75 miles per hour. Today I'm 9 weeks, 4 days pregnant, nowhere near finding out the gender and still scared of a miscarriage in the first trimester. It wasn't cleared by the ambulance, Your Honor. I refused the ambulance ride due to financial reasons. I was later checked out by months in ER in Cadillac, resulting with me having a large contusion behind my ear and a minor concussion. The total bill was $851 before insurance and $226.69 after. The total damages to my vehicle resulting in $305 for a windshield, $85.25 for an alignment, $394 for a wheel hub assembly, and $320 in labor. I only had the intent of a happy relationship and safe family relationship now being pregnant. I've never threatened this man under any circumstances. Throughout the last month of December, when the no contact should have been kept in place by both parties, I realize this man, Skylar Burris, is not a safe or loving man to have a relationship with. Your Honor, I fear for my own safety, my unborn child's, and the general public's safety moving forward. I realize my downfall in not reporting his prior occurrences of laying his hands on myself, but I have no doubt he'll lay his hands on another. Thank you, Your Honor, and I hope this is all in consideration.
Ms. Lawrence, is there restitution requests then?
There is, Your Honor. We just received some of those final numbers today. I did email Ms. Castles informing her of those numbers and providing that information. If she would like to request a restitution hearing.
All right, Ms. Castles, are you requesting a restitution hearing then?
Yes, Your Honor. We would like time to go through the accounts of what the restitution is, as well as to argue if needed.
Sure. Just so the record is clear, Ms. Lawrence, what's the total amount that's being requested?
$1,786.31.
All right, Ms. Castle's allocution.
So I'd like to begin by just giving context to what was found in the PSI. Under the current status, it's checked that he's unemployed. While he was gainfully employed for approximately 2 years prior to this case beginning, he did lose his job as a result of being in custody due to the bond violation. He does have another job lined up, though, for a managerial position with a different home improvement company. And he's advised that he will, his aunt will be providing transportation to him by allowing him to have a car to attend work and legal obligations. In addition to working full-time, he's also the primary caretaker for his grandmother, who's just coming off of a fairly serious operation. She intends to return home next week, and that's further motivation for Skylar to be out of custody and to be able to be home to take care of her. As the PSI notes, Mr. Burris's criminal history consists only of one misdemeanor offense Nothing assaultive. He's never been he's never been charged with any type of assaultive crime or accused of one prior to this incident either. As a matter of law, Mr. Burris isn't eligible for deferral under 4A because he's never been convicted of an assaultive offense. He's been found guilty of the present offense that qualifies under the statute, and he consents to placement on a 4A probation. 7694A was created to give individuals like Mr. Burris a second chance. He's in contact with his therapist and intends to address the issues that underlie this incident, as well as to gain skills on appropriately handling emotions and conflict in the future. During my conversation with Agent Bismack, she told me about excellent programs available that she may recommend he enter if sentenced to that probation. When I told him about these opportunities, he was all for it. He genuinely wants to better himself. Through this incident and this misstep, Mr. Burris not only gained a deep desire to not wind up in this situation again, but he also learned, although through the hard way, how important it is to comply with the conditions set by this court. The 14 days that he's spent in custody have gave him time to think and gain perspective, not only about his past actions, but also about the person that he wants to be in the future, about the father that he wants to be in the near future. So granting Mr. Burris deferral under 4A holds him accountable while still avoiding the lifelong consequences that a conviction like this carries. So we'd be asking the court to please defer proceedings and place Mr. Burris on that 12-month term of probation pursuant to 769-4A.
What is the status of his case in Grand Traverse, do you know?
I'm not aware.
Ms. Lawrence, allocution.
Thank you. I was informed, it's my understanding that Grand Traverse is essentially waiting to charge to see what happens with our case here in Wexford County. That is what I learned as of today. I would ask the court to follow the 12 months probation under 4A. The reasoning that people offered that in the first place is these are two very young individuals. I will say Mr. Burris does have a very lack of criminal history in this case. Ms. Harris has made it pretty clear she does want to see him get help. And maybe this is an anger issue. Maybe this is something that could be helped with counseling or therapy, things of that nature. It's concerning. His behavior is concerning. He punched Ms. Harris so hard she got a concussion. But I do think that maybe there is a deeper issue here that could be essentially rehabilitated with some type of counseling or therapy in this case. I will note I would still ask for the no contact order to continue. I know the victim wishes for the no contact order to continue. So I would ask the court to impose that as well as the 12 months probation under 4A. Thank you.
Did you say that Grand Traverse is waiting to charge?
That was my understanding, Your Honor. I think he was lodged for violating our bond conditions, not for.
Lean is showing that there's a bond order in place out of Grand Traverse County. It was issued the 3rd of this month with conditions of no contact with Ms. Harris, 500 yards from the victim, no weapons, no threatening behavior. Sir, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
Yes, sir. I just want to start by man-to-man apologizing for breaking the order that you laid down. To be honest with you, Mr. Wiggins, I didn't grow up with a dad, but I grew up with a mom. And my mom always taught me that a man's word is everything. I'm giving you my word today. You will never see me in this courtroom for something like this ever again. I've been going through therapy for my own issues. After all this is said and done, I feel like I'll do great with probation. I'll work with Ms. Bismack. You won't have to worry about me ever breaking any kind of contact order, violating any issues. To be honest with you, I'm super stoked to be a father. I never meant to intend to hurt Mrs. Harris. I look forward to raising a child. I look forward to going through this journey. And I just hope that you can understand that. At the end of the day, I know why you call your center a correctional facility. I learned that the hard way. I never want to go back to jail again. I want to change my life, and I look forward to being a father and a man. That's really all I have for you, sir.
When you were on probation before,
Yes.
back in 23, That was successful completion. Did you do a year or 6 months of it?
I don't remember, to be honest with you. It was, honestly, it was it was kind of like a low class probation. I think I only did 6 months
Do you remember what you had to do for it?
for as in like the statute of it, like
What your requirements were?
I just had to meet with her. I believe so. I just had to meet. That was pretty much it. I had never got in trouble with her. I worked with Sarah Bush out of the jail diversion program successfully. At the time, I was drinking. My mom had just went to prison. I was going through a lot of rough stuff, and I got clean. I don't drink anymore, and I haven't. Maybe that's where you guys think my anger might stem from. But I know that from the future on point, I'm going to be a man. I respect any decision you make.
I'll be honest, I have reservations about 4A in this case. That was one of the reasons why I requested a pre-sentence investigation report in this, because, usually when at least I consider a 4A, is it's kind of low-level domestics. You're lucky nobody ended up dead in this situation, including yourself. It's the way this sounds. And what I read in the report, when I took the plea, what I heard today, and what's written in this PSI is this just had to be an awful, awful experience for Ms. Harris. And then I'm left with somebody, and I understand the explanation for why we violated the no contact order, but we violated the no contact order, and it looks like there's charges stemming from that, which tells me this was more than just a simple violation of the no contact order. However, probation sees something, and I'll be honest, they see something I don't. Because I hear what you're saying,
Sure.
and I think you should ought to become a used car salesman, because you're saying all the right things, but I'll be honest, I don't buy it.
Sure, sure.
I have been in this system for quite a while as a defender, as a prosecutor, and now as the judge, and I can hear what I hear in your voice and the way you talk
Sure.
tells me that this isn't going to be your last go around with this. And I hope I'm wrong. I hope you prove me wrong.
Yes, sir.
But you're saying everything that I've heard for years and years and years. As I said, probation department sees something there. I requested their input. I'm going to go with their input.
Thank you, sir.
With one exception, I'm not going to do the 12 months. I'm going to do 2 years.
That's okay.
I know it's okay.
That's okay.
No, you had your turn. The reason I'm going longer is because this is more than just we got into a tussle and we fell in the living room. This is somebody almost could have been killed in this situation.
Great.
And so for that, I am going to go with the longer probationary period, also because we had the bond violation. Also because, at least as of now, we're expecting a child to come into this mix. And I will tell you from experience, that's not going to make things easier. So I will follow the 4A, 24 months probation. During that period of time, you're not to violate any law, report as ordered, not leave the state without the consent of the probation officer. Keep your contact and employment information current. Because this is a domestic violence case, you are not eligible for early release, so you'll have to serve that full 2-year term. During the period of time that you're on probation, I want you to attend any counseling pursuant to the terms of your probation officer. I want you to attend parenting classes. I know it's on here, but I'm not seeing it in anger management. There it is, anger management. You're also not to act in any threatening, violent, intimidating, harassing behavior, not to purchase or possess any firearms or weapons. You must also complete any additional programming that your probation officer orders. Ms. Lawrence, is there any indication of drugs or alcohol involved in this?
Not to my knowledge, Your Honor.
Ms. Harris, is that accurate? I'm also going to order a life skills coping class. There is a $75, and the no contact order will continue for the time being. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $50 fine, $150 court costs, $150 attorney fee, 24 months of probation is $720, 13 days jail with 13 days credit. That 13 days allows a $65 credit towards your fines, so that will be applied. Ms. Lawrence, anything else in a judgment of sentence?
Just to leave the restitution open, Your Honor.
So we'll set restitution at 0, And I will give 30 days to schedule for a hearing or resolve it. Ms. Castles, anything else in the judgment sentence?
No, Your Honor.
Mr. Burris, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. I'm going to waive that penalty while you're on probation. Also, because I have sentenced you to a period of incarceration, and you do have the right to appeal that decision. If you decided that you wanted to appeal it but could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney.
Okay,
All right? Mr. Burris, I hope you prove me wrong.
I'm gonna.
I hope you do. And
I'm gonna,
I
sir.
hope when you do that, you're right back here waving your finger in my face.
No, sir, I will not do that way, but
Well-
I look forward to proving you wrong in a great way.
All right. All right, at some point you'll be released today. It probably won't be in enough time to get you back over here to get signed up for probation,
That's okay.
but you'll need to report him. If you're not here by 5 o'clock, you'll need to report immediately first thing in the morning at 8:30 to the probation department.
Consider it done.
All right, anything else for the record, counsel?
No, Your Honor.
Does the no contact order stay in place with them? Are going to be lifted?
No, Your Honor.
I'm leaving the no contact order in place right now. It can be lifted upon request, but I want that request to come through me, not giving the authority to the probation officer to lift it. All right, thank you.
Mr. Wiggins, thank you for your time.
Thank you.
Real courtroom cases with no filters and no fake drama. Make sure you subscribe. These are real people, real crimes, and real consequences, and every case tells a story worth watching.